You are listening to Leadership Powered by Common Sense with your host, Doug Thorpe.
Well, welcome everyone. Today I have the privilege of visiting with a gentleman named Gordon Arnold. Gordon and I met through the Houston-based Silver Fox Advisors. We have known each other for several years now and worked together. And today the topic is about a question of law. Gordon is an attorney, and I'm going to let him explain his background in just a second here. And we'll also get into the topics of, well, I should say the details of the topics we want to talk about. The reason I wanted to talk with Gordon here is that any small business owner has a lot of things on their mind, obviously, when they open the doors and go about setting up their business. But in my experience, sadly, the probably most common mistake that a small business owner will make is avoiding or ignoring the legal ramifications of what they're doing. Most importantly is protecting intellectual property and the development of copyrighted like material and other aspects of that. And I'm butchering this right now, Gordon, as I think about it, and I'll let you tidy it up when we get into it. But
doing fine.
With that said, I'd like to introduce my friend and colleague, Gordon Arnold.
Well, hi. Thank you for having me. It's a real pleasure to be here.
So, Gordon, let's just start with the basics on your background. Tell us about your path in the world of being an attorney.
Well, it began in times not exactly like these, but a depression. I had gotten an electrical engineering degree from the University of Texas, and I was in sales engineering, flying around the country and trying to sell electronics of a certain sort to the aerospace and the oil and gas industry. And the bottom fell out in the 80s. And like a lot of young people now, I ended up going to grad school because you had to do something to occupy your time. So I ended up in law school because it seemed like I knew an awful lot of old lawyers who didn't want to quit what they were doing. And I thought, well, anything that can keep people going until they have to get dragged away from their desk, maybe that's something to look into. And it turned out I liked it. And that was over 30 years ago now, and I'm still doing it. So I guess I like it. And I've ended up, because of the engineering degree, ended up the only job that anybody would give me was being a patent lawyer. And then I was shocked to find out that I enjoyed that a lot. It seemed like it would be kind of boring, but it's got more variety, I think, than just about any other area of the law.
Interesting. So can you describe, just in a kind of a quick summary, what focus areas you work on today?
Well, it's intellectual property, which is not just patents. It's patents, trademarks, copyrights, trade secrets, non-compete agreements, joint development agreements, technology agreements, all the litigation that comes around enforcement of intellectual property or defending against somebody who's asserting their intellectual property against a client. Sometimes in a lawsuit, we'll be on both sides in that we've got a client that's being sued for patent infringement, and they're also suing the opponent for patent infringement because they're competitors and they've been developing in the same area. So that's a long answer to a short question, but it's anything involving very complex litigation and also the application work and the contract work surrounding it. And as a part of that, now more and more, I'm getting into the strategy work with clients on how to protect their products and services, both so they have freedom to operate, but also they have an avenue to go after people who are competing unfairly against them.
So let me throw down a kind of a quick and maybe simplistic example. So I'm an entrepreneur. I've got this great idea for some kind of widget I want to build in a nice little factory. I put that together and I go out and then I invest in hiring a marketing person that helps me come up with a really catchy name. And we spend dollars on advertising and promotion. And next thing we know, we get a letter from somebody we never even heard of who said they had the first right of that name. They've got proof that their widget is called almost the exact same thing that I've now called my widget. What am I up against?
Well, the typical lawyer answer is it depends. And it depends really on a number of factors: the aggressiveness of the party on the other side, their budget, how similar you are. And in a lot of ways, it depends on how threatened they feel. If someone is not feeling threatened, but they're policing their trademark to try and make sure it isn't weakened by other people coming in with not identical, but something that they fear might be said to be confusingly similar, something might be able to get worked out. On the other hand, if they feel like you're potentially going to take money out of their pocket, it's going to be a whole different discussion.
You know, I'm reminded of a story that is in a video archive somewhere now. In the early days of Southwest Airline, Herb Kelleher, one of the founding members there, was given notice by a little outfit in Florida that they were called Southwest Air or something like that. You may know those details better than I, but it was
way back.
It goes way back. I think this is
the arm wrestling settlement.
And Herb, being the champion marketeer that he was, he concocted a wrestling match with the guy. It was going to be an arm wrestling, but he made it up like a WWE kind of event, and showed up on a Harley and with all his cheerleader stewardess folks, which is all horribly politically incorrect today. But nonetheless, they made a big event out of it. The gentleman in Florida got a lot of publicity for it, and they traded the names. So
I remember the settlement. I don't remember the details. I remember thinking at the time how brilliant it was that these two guys got together and said, you know, if we have a fight, I'm just making this up now. I'm betting the two of them said, if we have a fight with the lawyers, we're just going to spend money. But I think they must have known how they were going to settle it, because they weren't in a position where one of them had to win and the other one had to lose.
Right.
They could work out I'm guessing they worked out what's called a concurrent use agreement. And as I remember, it was pretty clear that Southwest was probably the junior user, and so something got worked out. And then Kelleher, who was probably older than I am now at the time, and like me, a tall, skinny guy, he shows up, as you said, just dressed to the nines, acting like he was the toughest guy in the world. But the guy he was against, you know, in an arm wrestling contest, he was young and fit and muscular, and there was no way Kelleher was going to win anything with this guy. And I thought it was a brilliant way of handling a business dispute. And I'm arguing against my own self-interest in that sometimes you don't need the lawyers if you can come up with a creative idea on how to take care of something and make it beneficial to both sides. A dispute can be an opportunity.
Well, not to belabor the story, I'm kind of keenly aware on it. In my banking days at Texas Commerce, Herb was actually on our board, so we were regaled with many of his stories along the way. And you're absolutely right. I assure you, there was an army of attorneys that had worked the deal and come to that conclusion. And Herb being Herb, he saw an opportunity for some branding, and helped sprinkle the icing on the cake with the other gentleman, and said, this could be a win-win. We'll both get a lot of PR, and how about we do this? And the guy agreed, and it was a hoot. It was quite an event. But
not unlike what we see in some of the allegedly professional wrestling or legacy boxing matches, rematches that we see nowadays.
Yeah, well, let's not let this show digress to that. But
okay.
So, what is there such a thing as some basic advice you could give a business owner about how to go through the process of analyzing and thinking about what they ought to be concerned about?
Yes, the first thing is learn the system. And there are very few people who come out of college or graduate school who have really any working knowledge of the intellectual property system. And it's kind of remarkable to me that that's true, but it is. It used to be I would get called by somebody and they would say, I've got a new idea. I've got this new product. We're rolling it out. The marketing is going forward. We want to hire you to do a patent application. And I might say, okay, do you want me to do your trademark work too? And they would say, yes, great. And they would send me the information. We would work on the applications. We would file the applications. Many months, a lot of money would get spent. Many months would go by, and maybe a year and a half into it, the client would say, well, if I'd known that, I wouldn't have gone this direction. I would have gone this other direction. And I realized that in the time that I got to know the client and for the budget that we had, I couldn't predict what that was going to be. And the client couldn't either, because they didn't understand the system well enough to integrate that into their business plan. So before you spend money on the lawyer, and preferably before you spend a whole lot of money on your marketing and your rollout, you need to learn the system and learn what to budget, how long things are going to take, where the risks are in engaging in various forms of intellectual property registration or application work, and where the opportunities are. The numbers get pretty big pretty fast. At least the total numbers can look pretty big. They get spread over time. And so what I've started doing now is, if I've got somebody who is new to the game, the first thing we do is we have a 4-hour meeting. I always do it over lunch. Well, I do it over lunch if I can. I'm trying to learn how to do it over the internet this last year, and interesting successes and failures on that. It's not the same as standing in front of a whiteboard, where I'm more natural there because I've been doing it that way for a number of years now. But you need some kind of interactive process where I can learn what the business model is, what the model for the product is. It's not so simple to just say, here's a widget and here's what we're going to price it at, and here's our trademark, run off and do something. Inherently there's a strategy behind that. Or if there isn't a strategy, there needs to be one, because trademark application work costs thousands of dollars. Patent application, that's spread over a year to 18 months. Well, maybe not quite that long. Patent application work, that's a series of $2,000 to $3,000 to $5,000 chunks. By the time you get a patent application on file, if you don't have an in-house patent counsel, if you don't have experience, you're going to spend anywhere between $5,000 and $25,000. Usually it's a little over 10. And you need, before investing that, people need to understand what's the return on the investment that they're going to get in the lawyer fees. A lot of times we lawyers think of ourselves as providing a service and getting a fee, and we don't think in our mind about the return on the investment the client is going to get, if not in cash, then in value. And the client a lot of times isn't thinking about that either. They just want protection. And a lot of times I'll find out they don't care that much about stopping a copyist. They just want freedom to operate. Well, that's a different analysis. People sometimes think, if I get a patent, I can't get sued. Not true. You don't need a patent to keep from getting sued, and having a patent doesn't mean that someone isn't going to sue you. The patent is there so that you have the ability to go after an infringer, but it doesn't mean that what you're doing is blessed by the patent office. It merely means that the patent office had said, here's a key to the courthouse door if you want to pursue an infringer. But someone can sue you for a lot of different reasons involving that product, and the existence of the patent itself will not prevent you from having liability. This is something that a lot of people are surprised about. So getting into those differences and the nuances and what's the business strategy, and developing a budget, and all along the way, importantly, say, what's the return on the investment that I'm going to get for the money I'm going to spend on this lawyer, is the real key for the client. And if they don't understand the system and what the benefits and the risks are, they can't make that decision. And I can't make it for them, because unless I don't make it for them anyway, I can't even give them the different avenues that are possible for them unless I understand their business model. Mm-hmm. And that takes about 4 hours plus the follow on the next day, the next week, as people come up with, say, well, now what did he say about that? And they call back on the phone and work something out.
Right.
If I end up with someone that doesn't, that decides not to hire us to do anything, I've probably still got a very happy person because they feel like I stopped them from wasting a bunch of money. On the other hand, there's almost always something more for us to do. And then I've got a happy client because they're not going to end up 18 months later saying, well, if I'd known that, I wouldn't have done what we did.
Right.
And a long answer to a short question.
Well, let me shift gears just a little bit and think about the entrepreneur or startup owner that is one of these, they aspire to be a thought leader in a particular niche. So they open up a website, they start blogging and maybe podcasting, video, or they, even more sophisticated, they develop some courses that they're trying to sell to talk about whatever area they work in. Every quick and easy website software that I know of has a placeholder at the bottom to put a copyright notice on it. Does that buy me anything if I'm one of those guys?
Yes, but it doesn't buy you nearly as much as registering the copyright on your own content. Again, let's talk the difference between protecting your stuff and freedom to operate. We'll put freedom to operate aside for a moment. That's very important in this area, by the way. A copyright allows you to go after somebody that copies your content and stop them. And the copyright law is extremely powerful, especially because it provides that you can be awarded your attorney fees for enforcement of your copyright. That makes the investment in the litigation itself much different than if you were precluded from obtaining your attorney fees. Secondly, proving the monetary damage that you suffered when someone infringes your copyright can be very expensive. So that expense, again, can change the investment in the copyright suit from one that's a good investment to one that's a poor investment, risk adjusted. If you have not registered your copyright before the infringement begins, and there's some other rules along that line, but if you have not done that, then you'll be precluded from getting your attorney fees. That's point one. There are basically fines. They're called statutory damages, but they're basically fines that the infringer has to pay to the copyright owner that run up into the hundreds of thousands of dollars and many times many hundreds of thousands of dollars for what would appear to be simple acts of infringement. And those are an incredible help to make the assertion of the copyright valuable, because you don't have to have the expenses of an expert witness to make an economics model and do all of the things that, or you don't have as much expense anyway. Well, those are also precluded if you don't register your copyright before certain events, such as before infringement beginning, if all of the different rules apply. It doesn't make sense for a client to get into all the rules that apply as to when I'm okay if I did not register the copyright, because probably 80% of the copyright registrations that need to get done can be done by a client on their own. They may need to hire us to walk them through it a few times, but after that, you can get an assistant to start turning a crank. And the fees at the Copyright Office are very, very low compared to the benefit that you get for that. So that would be the most important piece of advice I ever give anybody is register your original work, whether it's the text, the website, the photographs, anything that's original to you. You may need some help figuring out how to bundle that together to reduce the office filing fees. But once we set up one of those processes, that's something that a client that's generating content should be able to do on their own if they want to, or they can hire somebody like me where it's basically going through a paralegal, excuse me. And that can be done on an ongoing basis.
But is there in the copyright world, is there a kind of a notion of an evergreen envelope? I mean, if I'm a blogger or a podcaster, I'm pumping content maybe once a week or more. Do I have to register each one of those, or just the fact that I'm a publisher of that content?
Well, the answer is yes, you have to register everything that you're going to want to assert in the future. Sometimes we get into a lot of discussions with clients about, okay, if we register everything, then that's cost prohibitive. What are the things that would really, we go into an analysis that's somewhat in depth to try and help the client figure out, okay, if someone takes this or that or the other, these 4 or 5 things, I don't really care. If they take these other 3 or 4 things, I'm really angry. And then there might be some other things that it's actually beneficial for somebody to copy because somehow what's the old saying is that copying is the sincerest form of flattery.
Right.
Well, if you can find a way of tying your trademark to the fact that somebody copied you and it's gone viral, that's not a bad thing either. So setting up your marketing and your website and the like in ways that you discourage the copying of the stuff that would make you angry if they did, versus not spending money on a lawyer when you don't really care, or even finding a way to have people do things not only like link to you and do other things where you're getting essentially free advertising from it. That's where I like to spend a lot of my time, because that's generating value for a client where they immediately see the benefit in my fees and I don't have to justify them. But the one thing that you don't want to do, and this goes to patents and everything else, is don't rely on the post office. You can't write something down and mail a letter to yourself and get any significant protection. It's not cheap to get proof of what you thought up early on in a way that will benefit you in court. But relying on the post office isn't the job. That's not what the post office is for. That's what the Copyright Office and the Patent and Trademark Office are for. Great.
Well, Gordon, I'm looking at the clock here. What I want to do is we're going to take a quick break and come back on the other side. I do have a couple more questions for our audience, and we'll see you in just a moment.
You are listening to Doug Thorpe's Headway Momentum Series. When you want to make a difference right where you are, you need momentum for the journey. You need Headway. Here's Doug.
Well, we're back. I'm visiting today with Gordon Arnold, who is a patent and copyright attorney, and I always fail on properly stating that title. Gordon, you want to clean that up for me?
Well, the general area of practice is called intellectual property. That's patents, trademarks, copyrights. It's inventions, works of authorship, branding, some amount of employee relations, non-competes, joint venture agreements between companies where they're jointly developing technology and who is going to own what side of the technology at the end of things. That general area that's called intellectual property.
All right. Thank you. Well, so on that note, as I mentioned at the start of the program, we're focused on talking about small and mid-sized businesses and the things that they may do or not do when you start your business and you get it up and running. Quite possibly, and I certainly see it in my client base, I run into people that just simply haven't thought about it much. They get busy creating their product or service. They might spend some money on marketing to come up with that really wow name that gets them out there and gets attention coming their way. But they quickly run into some scenarios where either they are threatened by a competing company, or might not even be competing. It might just be somebody in a whole different realm who claims rights to the name that you've chosen. That's one area. Or you may discover somebody else is doing something like you, and you want to somehow protect what you're doing. So Gordon, what's an owner to do? And maybe better, the question to start with is, let's just summarize what they ought to do in the early going. What boxes do they need to check to set this in the right direction?
Well, the first thing, as I said, is to learn the system, and we talked about that. And during that process, excuse me, during that process, they will learn a lot of the detailed answers to your questions. But as you bring up, there are two issues to protecting your stuff. One is, how can I stop somebody that is doing something that is taking away my customers, or is copying my product, or is hurting my goodwill, or is using my invention? That's the assertion side of things. And the other side is what we call freedom to operate. How do I avoid having problems with other people? Let me focus on that one now, since I was focused more on assertion and application work in the first half. Freedom to operate, first off, involves searching to see what other people are already doing. And some of that can be done simply by internet searches. And boy, that cleared out a lot of stuff early, since the internet came along, than it did before. But after that, you still need to go into what are basically access to paid databases to find what are the things that people have registered, what are the things that are out there that may not be exactly the same as what you're doing, but they're similar. That's and the patent and the trademark side of things. And then before, as a hunter would say, silhouetting yourself against the sky, before filing a registration or going public in a way that might force them to come after you, you might have the opportunity to design around someone else's patent, or to choose a trademark that would be just as valuable to you, but would be less threatening to the other side. On the copyright side of things, where it comes to works of authorship, it's really about making sure you've got a good source for the content that you're putting in. If it's not yours, then that you're getting a license, and that the scope of the license that you're getting from whatever organization says they have the right to the song, the image, the text, or whatever, that you're getting a license that is broad enough to cover all of the uses that you want to put that content to. Because most of the time the rights are chopped up, and if you simply get a license, it may not be one that's broad enough for your intent.
You've mentioned knowing the system a couple of times now, and a thought that comes to my mind: is the system keeping up with the evolution of social media?
That's a really good question. And at this time, I don't have an answer for that. The system itself always needs tweaking, and the fights occur on how much tweaking should be done, who should do the tweaking. Should it be the Congress or the regulatory agencies or the market itself? And each of those three bodies bring different tools to the table. Some have very blunt sledgehammers and others have scalpels, but it's easy to pick up a sledgehammer and swing it. It's hard to get a scalpel to very carefully use it. And if right now the example is the social media groups, and for lack of a better word, the censorship that they are deciding that they must impose, or they feel they should impose, or not. Those are really difficult questions. And I think we're seeing that play out now. Depending on what your interest group is, you'll have a different and maybe a very strong reaction to that. The good news is the overall system that we have does have sledgehammers and scalpels and a lot of tools that are used somewhat. It's an ugly sausage making process, but it does go on, and over time it has tended to serve us well.
Well, just in disclosure, I'm not an attorney, but I've been accused of playing one on TV, and my experience in that realm says that oftentimes I hear discussions about case law, that case law becomes the precedent for certain issues if if the exact transaction or situation you're dealing with happens to bleed over into a certain area, there's always this talk of going to case law to see what's the current and most recent. Does that happen a lot in this intellectual property realm?
All the time. And if you think of case law, there's a statute that's written by Congress, and then there's a regulation that the administrative agencies will put together interpreting the statute. Well, that's all fine and good, but ultimately the test is in a given fact pattern where one plaintiff sued a defendant, and it got up to a place where there was a determination by the court, either the trial court or the appellate court. Then there is an opinion that's written and a determination that's written where the court makes an absolute, or not an absolute, but makes a definitive decision. We can then look at that as an example of if you go down the road that this defendant went down or that this plaintiff went down, you can see what happened to them. Your situation is never going to be exactly the same. But if we take a number of examples, we can begin to see, well, here's a fairly open path, and here's a path that's fraught with the potential of landmines. And that's the use of the case law as examples.
So have you seen situations where a well-meaning entrepreneur starts out on a path with a product or a service, and because of someone else asserting their rights, does our champion entrepreneur get forced to just shut down?
That can happen, yes. It is fairly rare. One of the more recent patent trials I had, there was never an opportunity to settle with the other side. The other side simply wanted my client shut down. There were, I forget the total. I think there were 12 patents and many hundreds of definitions of inventions, and I think 4 accused products. Ultimately, after the trial, there were a number of products that were enjoined, but we were successful in getting the definitions of the inventions narrow enough that the company was able to continue operating and was able to get refinanced. But they certainly were hurt in certain markets. And a lot of that has to do, when these things happen, a lot of it has to do with lack of planning on the front end, because much of this can be avoided if we get involved at an early stage.
So I think that's the big punctuation point and word of caution and encouragement to our audience here is to think about what it is you're doing, and if there's any potential encroachment or overlap, maybe is an easier word to understand, if with someone else's product or service, it's wise to seek counsel, run your vision through a lens of having someone like a Gordon Arnold understand it and give you the feedback you need for the course you need to be taking. Is that a fair statement?
That's very fair. The initial impression people say is, there's nothing like that out there that I can find. That's great. But there's probably some stuff out there that the professional searchers can find that you ought to consider. And that doesn't cost very much as an insurance policy compared to getting a cease and desist letter after you've invested tens of thousands or hundreds of thousands of dollars in a rollout. And then you're going to have to change all of your marketing, even if you're able to continue in the business.
I'm going to close with a story, and I guess everybody else is going to have to be the judge of how this fits or where it goes. But I was reading in the headline news just yesterday, there was it turns out in all the focus on the pandemic and the testing for the COVID virus, those infamous swabs that have to be put up your nose and inserted all the way back almost to your brain cavity. Those are very specialized swabs. And when the pandemic hit, the government was scrambling to determine how we were doing on the supply of those swabs. And very long story short, it turns out there's only one little factory in the state of Maine that makes those swabs that are suitable for the level of flexibility and the adherence of the material on the tip and all of it's a very prescriptive construction to make those swabs and have them be sterile, having them be a true pristine environment to get the sample and then release the sample when it needs to be released. So it was a very long and arduous task. And as the story went, to your point, Gordon, when the government started trying to figure out where those came from, they were doing some searching, and at one stage they thought they had found 12 sources, but only to discover that those 12 were nothing but distributors. They weren't the manufacturers, and it was just one little factory. And there's a whole other side story about what's going on in that factory with it's a family-owned business, and there's some friction in the family, and that's another whole side story of that. But
we could do a whole hour on that easily, on those stories. Yeah.
They were infused over $250 million to ramp up production and satisfy the national need for those swabs, to get ultimately every American the ability to be tested, and tested multiple times. So they were able to ramp up the facility that they were doing. I forget the numbers. It was unbelievable numbers in a manufacturing sense of units per minute or hour going through that plant. But I'm thinking, those guys are sitting there going, do we need to protect our patent? Do we need to protect our activity? And lo and behold, they were, at the time, they were the only one that existed doing that.
Well, though I don't have a crystal ball about the future, when the next pandemic is going to be, or when a client is going to have a specified know-how for a very specific niche market where their family dynamic is being satisfied by what they're doing right now, and it gets completely destroyed by the necessity to ramp up by many orders of magnitude, which will completely destroy the business model that apparently has been working for the family. I wasn't involved in this, so I'm just guessing, but I've seen this happen. So I don't know how to protect against that. I do know that many times what you're talking about, a lot of the intellectual property is trade secrets, or, for lack of a better word, know-how. Somehow they knew how to get everything right and deliver that product to the market they were addressing at a price point that the market could handle it. The alternative technology wasn't worth buying, and I presume they were making some money on it. All the decisions that led them to that point could have been different along the lines, and they might have absorbed they might have already had a plan for growth and other things, but it didn't exist. The market didn't exist till the pandemic came. So I don't know how to plan for the next black swan.
Right.
I do know that when that black swan comes and the tidal wave comes, there are then some things we can do from a legal perspective to try to protect things going forward. But until we know what that event is, it's planning for a black swan.
It's out there. Well, Gordon, this has been great. I think from a time constraint, we probably ought to wrap it up. Tell folks how they can get in touch with you.
Our website is arnoldsaunders.com. We also have it at arnold-iplaw.com. And that's probably the best way. The other way is to go to the Silver Fox Advisors webpage, and I'll let you quote the exact URL because I've forgotten. I'm listed there as one of the associates that sometimes the Silver Fox Advisors will call on to help out with various projects. So I'll let you give that part of the
Yeah, thanks, Gordon. So yes, the Silver Fox advisors can be reached on the web at silverfox.org. That's org. And it's a real simple URL. As Gordon alluded to, we have a full roster of all of our membership. The organization is celebrating 35 years in existence in the greater Houston area with the mission to serve small businesses, help owners with growing their business and advancing their cause. So we do that with a blend of all kinds of skills and abilities, as Gordon represents the one dimension of the law. I do executive coaching and business advisory work. I've spent 20 plus years in banking, so bring that to the table. But I have most recently in the last, well, recent's a relative term, last 15 years, been doing executive coaching and the formal advisory work. So we'll be happy to talk with you as well. And my information is simply at the name dougthorpe.com. You can find my blog page, and I've got a lot of articles and content about leadership development. And as one of our other Silver Fox associates taught me, there's an invisible wall between management and leadership. So as you go out developing your company, you may well figure out how to manage the process and get your work done. But if the company grows at all, you're going to reach that invisible wall, and you're going to need to be thinking about some actual leadership to be able to take the company and the business to the next level. So that's it for our time today. Again, Gordon, thank you so much for your time.
My pleasure. Thanks for having me.
And you can reach both of us on the web. And I'll say we're out. Have a great day.
Great. Thanks again.
This has been Leadership Powered by Common Sense, hosted by Doug Thorpe. For more information, visit us on the web at dougthorpe.com.